Get yourself a suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
And it is 10:05. You're listening to Mary Gearin. I'm filling in for Virginia Trioli today. And yes, it is the regular talkback segment with David Whiting. He can give you free legal advice. Call on 1300 222 774 or text 0437 774 774. And it is my pleasure to be actually looking at him in person as we sit here on the Geelong waterfront. Hello, David.
Hi, Mary.
Great
Over
to
the
see
top
you.
of a screen.
Over the
Yes.
top of a screen,
Yep.
that's right. How was the commute this morning?
I caught the train.
Yep.
Come to Geelong. I mean, I was talking to your producer before. It's a nice place to come for dinner. You can get down in an hour. Lots of restaurants within walking distance of the station. You go home.
That's a terrific idea.
Yeah.
I must admit that never occurred to me. Do you have much of a history with the region? Do you come here? Do you come here often?
Do I come here often? No, maybe once a month, once every 6 weeks.
Yep.
Some work, some social.
Yeah.
So, yeah.
Dip in the sea?
I can recall having swum at Eastern Beach, but that was quite some time ago.
Didn't jump off the pier then?
No.
Terrific. Oh, well, look, he is here anyway in Geelong, but you can call him from anywhere to put your legal questions to him. Let's go first to Lee from Geelong, who has called in. Hi, Lee. What's your question to David?
Hello, both of you. David, look, I was lucky enough to ask you a question a couple of weeks ago about I'm an applicant in a VCAT matter and the respondent hasn't put in their evidence in time, and you said I should try and get it struck out.
Yes.
But I want to know is there a particular application I need to fill in, or do I just ask for it verbally on the day of the court?
Oh, well, if you're already at the tribunal, what you ask is it struck out because there's been no defence or response? And it's quite possible that the tribunal may allow you to run it as undefended. So if you're ready to go, then perhaps you might be able to get the tribunal to deal with it then. So
but is there an application form I need to fill in, or?
No, because you're already before the tribunal. You told us that you presumably already have a date. Is that for directions or a hearing?
There's a compulsory conference listed for a couple of months' time.
Okay, well, in the compulsory conference, you're not going to get that order unless you turn around and ask for it to be sent to a member for the purpose of having their considering an application to have their application removed, their response struck out, so it proceeds undefended. But there's no particular document. It's an application that you make as part of your attendance at the compulsory conference.
Good luck with that, Lee. Is that a good answer for you?
Yeah, so I just need to ask the VCAT member beforehand.
No, at the compulsory conference, you turn up, the other side turns up, or even if they don't. So let's assume they turn up, your response is they've not sent you any material, they've not filed any material, and you would like the tribunal to list the matter for a hearing on the basis that it proceeds as undefended, and that will cause at least some panic from the other side.
And just to clarify, David, they did send it, but it was 2 weeks late.
Okay, well, you've now got a defence. So
there's
a difference between not having it and getting it late. The theory is that we all want justice to prevail, and that means that they will consider both your claim and their response. So you won't get a summary judgment application up on the basis of the information, because the information's already there.
So you might have something on your side there. Thanks for calling in, Lee. Kay from Gisborne has called in. Hi, Kay, what's your question?
After the storms in Gisborne a couple of weeks back, we've got a play group at the rear of our property, and it's got a lot of large trees.
Kay, you rang and spoke to the Mayor of Macedon Ranges Shire Council, didn't you?
I did. That was about another issue. This is another one.
Yeah.
The trees across the back of the block are on the playgroup's land, and it's owned by a trustee, and it's managed by a management group. And we've been dealing with the management group trying to get them to tidy up the trees. After the storm, we had a whole backyard full of branches. Took 4 people and a truck for us to clean it all up, and broke our chicken shed. But what we want them to do now is clean them up on our side. They've had 3 arborists in that have cleaned them up beautifully on their side, And I invited them onto our property and they haven't done it. So
Kay, why don't you just lift up their branches and push them onto their side of the fence?
Because it's a playgroup and we don't want to put the kids at risk.
Well, and the playgroup isn't responding to your requests?
Oh, they're saying they're getting back to it, but we're still waiting. So we're just wanting to know what our next option is.
About a month ago, I got approached by someone who was really concerned with overhanging trees, and the neighbour was about to sell. So in the end, we needed to prepare proceedings for the Magistrates Court. My difficulty is going to be that the cost of running your argument that they are encroaching onto your property and they've got to remove their branches is going to, at the end of the day, cost you more money than the cost of removing the branches. And remember that you're bringing an action against someone who's probably got next to no money. So if I was to look at the best investment from your point of view, I'd be asking the playgroup, could they put together a working party to come and remove the stuff from your property?
Yeah, surely, Kay,
it's
in their interest to come and do that, have a working bee.
We've actually removed it ourselves. There's a whole lot of hanging branches in the tree that are going to fall. So we're asking them to tidy up the hanging branches. We've actually done the big clean-up.
Kay, it's negotiation or the Magistrates Court.
Okay.
Now, the second one is going to cost you more money than fixing the problem yourself.
I know what I'd rather do, Kay. Hopefully a nice cuppa can really sort this out for you. That's my faith in a cuppa. Thank you. Thanks for calling in, Kay, and good luck with that. Margaret from Macedon Ranges has called in for you, David. Hi, Margaret.
Good morning, David and Mary. I'm actually ringing for a friend. A family court registrar gave orders that allowed the father of her child unsupervised overnight stays. Now, this order was against the advice of Department of Human Services, and it puts the child at extreme risk. The registrar gave no reasons for the orders.
Have you asked for reasons, have you, Margaret?
On any sort of safety. So what options does
Margaret, just to interrupt.
Margaret, have you asked for reasons? Normally you're entitled to ask for reasons.
The reasons, I believe, have not been given. She asked for a stay of orders, and the barrister at her cost went before the same registrar, so the orders...
Yeah, you would normally make a stay application before the judicial officer who made the first decision, because that person's got the best information. Your friend has two options. Defy the orders and then you'll be dealt with for contempt of court, or seek to have the orders reviewed or appealed. But the processes in the family court jurisdiction are such that there will be many instances of access in the period that you've got this under review.
Yes, but while it's under review, that child is going to be put at extreme risk. That doesn't seem right to me. While it's the waiting process.
Margaret, the problem is that while there's what you get from the judicial registrar is, what you get from the department is a report that the judicial officer is required to take into account. If there is a change, the difficulty is, and I know it sounds the wrong thing, is that every dog is entitled to one bite. So, and I know when we're talking about children, that's a very poor turn of phrase, but you're going to be able to get a new decision based on the father's behaviour, not just on the basis of the report. So you can appeal the decision of the registrar, but that's going to take some time, and the orders will remain in force until that happens. So your friend needs to go off and make a tactical decision about what's in the best interest of the child.
Margaret, it's such a tricky situation, and I really do wish you the best of luck with that. Those sort of situations and problems are so difficult. Thanks for calling in. And I want to tell anyone who wants to get this free legal advice from David, the number to call, 1300 222 774, or text on 0437 774 774. Brendan from Maidstone has called in. Hi, Brendan.
Oh, hello. Thank you for taking my call. I just have a couple of queries about my rental property. The real estate agents sent out notices about the inspection and saying that I have to provide the photos. rather than them coming and doing the inspection.
Yes.
And also repairs. They sent out the notice saying that if you need something repaired, I need to do it and then put the receipt in and claim the money back. Is that? I don't know that that's actually right. Is that correct?
Which
right?
bit? I mean, let's deal with the inspection one first. I rather like the idea of the photos rather than the physical inspection. A friend of mine got a note from the estate agent saying, we're coming to do an inspection, and these are supposed to be by appointment. The nominated times for the appointment were between 9 and 5. Now, and if you're not there, we're going to come in because we've got a key. I think that's contrary to the Residential Tenancies Act, because I'm going to turn up sometime in the next 8 hours is not an appointment. So, but I do like the idea of the photos, if you're satisfied with the photos. And remember, you can take them on your digital camera and you can email them off. In terms of the repairs, you're entitled to have them undertake the repairs. So you're not required to do the repairs. You can make them arrange the repairs. But here's an opportunity for you to get it done to the standard that you want, and an opportunity for you to choose the tradesperson.
Brendan, do you have a problem with actually taking the photos yourself? Why do you object to that?
Well, it's not my job, is it? It's their job. I feel like I'm doing their job.
But just in terms of the advantages, having not that invasion of privacy, you can send away, what you see as the problem?
You can refuse, Brendan. You have the right to refuse, and so if you want to inspect, come and inspect, make a time. And if there are repairs that need doing, you're entitled to bring it to their attention. If they don't deal with it, you can take it to VCAT. But we're really talking about turning transactions that might take hours into transactions that might take months.
Good luck with that, Brendan.
Yeah.
I hope that answers your question.
Okay,
it's 17.
Bye-bye.
It's 17 past 10 and you're listening to Morning's program, and this is the regular Talkback segment with David Whiting. Please do keep calling in on 1300 222 774 if you have a legal question. Melissa from Point Lonsdale has called in. Hi, Melissa. What's your question for David?
Hello, David. I just have a question in regards to a local lifestyle village here. My mum has recently moved into, and you have to provide your own, you can provide your own window furnishing. So she happily went along and spent a lot of money on plantation shutters, which are the white blinds that very...
I know what they are, Melissa. I mean, I want to be very careful because you've told us where you are, you've told us what the business is, we're actually getting fairly close to specifics, but keep going, right?
Well, so, just in general then. General.
Yes, let's try. Yep.
Just in general. So my issue is we had absolutely no idea, even though I'd read through the contract quite, thoroughly, that was not allowed because when we're driving around the village, there's lots of there's two different ones. There's the pull-down blinds that they provide, which are very minimal protection and whatever, and there's also shears. Anyway, the plantation shutters offer more privacy for my mum because with blinds they're either open or shut. She can open. Anyway, we were happily going along, and then she got quite aggressive directions.
I think, Melissa, you need to look and see what the rules of the village are because they're the contractual obligations that your mum's
Correct.
got.
Yes. I 100% agree with you, but it does not say that you can't have a specific window furnishing. It just says you can't have decorative items, which I completely understand. We would never put pots or, anything like that. And there are a few alternatives around villages where people have made a living window, which is beautiful, and that's open for everyone to see during the day. And I just...
Melissa, you're going to have to get someone to sit down and read the contract with the retirement village or the lifestyle village and work out what she is or isn't allowed to do and work out how you want to handle it from there. It's a contract dispute between your mum and the place that she's renting from.
Melissa, it sounds like, you've got a little bit of homework in terms of sorting through some, no doubt, confusing legalese, but it sounds like that's what you're going to have to do. Good luck with that.
How do you define what decorative is? That's my issue.
I wouldn't have described plain white plantation shutters as decorative.
Yeah, thank you. All right. Well, thank you for your advice.
Thank you. Thanks, Melissa.
Thanks, Melissa. Alan from Knox City has called in. Hi, Alan.
Hello.
Hello. What's your question for
Hi.
David there, Alan?
The question relates to the property adjacent to where we live. A developer has bought the property and requested that the trees on our side of the fence be cut down. Now, we're reluctant, but fearful that the trees might be poisoned.
Yes.
If that were to happen, what defence would we have? What could we do?
Well, the law doesn't cope well with trees, Alan, and neighbours, right? The law appears to have been developed when everybody planted one tree in the middle of a paddock and it upset nobody.
And there were no fences, no neighbours.
What we now have is people who've got plantations in the suburbs adjacent to someone else's property, and there are lots of overhanging branches issues, and there are also intrusive root issues that you see from time to time. It, in theory at least, is your obligation to make sure that your trees don't encroach into your neighbour's property. Now, aesthetically, that might be an absolute mess, but that's the way the law's formulated. Your trees, your property, keep them there. So
does that apply to both overhang and roots?
Well, most people aren't too fussed about the roots unless they're roots that turn into surface roots, or the roots extend to the point where they're interfering with structures. Now, that to me is the practical answer. Some landowners have a more stubborn view, but to me the biggest issue is the overhanging branches. So
best of luck with that, Alan.
I don't know how far you encroach. I would probably go and get an arborist's report if you're worried about somebody poisoning the trees, so that you can get an assessment of their current health and condition, and if they start to deteriorate, then someone will be able to tell you what the poison used was. But your only other option is to put a security camera on your trees, which strikes me as fairly unreasonable.
Yes.
Oh, good luck with that, Alan. Thank you for calling in. You're listening to the regular Talkback with David Whiting. For free legal advice, we are both in our pop-up studio in Geelong, and calling in from Torquay is Helen. Hi, Helen. What's your question for David?
And David, I have a residential unit in Belmont, which is a suburb of Geelong, and over COVID we had a tenant there who apparently had a brain tumour, and several months after he vacated and went back to India, we got a VCAT, a notice that he has applied to VCAT, claiming that because we wouldn't reduce his rent and because we didn't give him back his bond when he vacated and we had to clean the place and get a new tenant, that we caused his brain tumour, and he is asking for $100,000 from us.
Wow. Yep.
Okay.
Is there any possibility that VCAT could find that? I mean, what should I do about that?
Well, have you given you the medical evidence for cause and effect?
Well, he didn't do that when he was first diagnosed with it. A cousin or brother just rang the real estate agent and said,
Helen, I just don't see the connection. Right? I would have thought that the prospects of you losing that would be incredibly low, but it's not a bad negotiating point to start with. There would need to be medical evidence with cause and effect. There's a Latin phrase called post hoc propter hoc, which is something happened. It's what you're really doing is saying something happened before something else did, so it's cause and effect. Just don't see it. Need to be medical evidence. I think I'd be sitting down and doing a timeline to look at all of your interactions with the tenant. Just don't see it. And an action for damages isn't brought at VCAT. So your other argument, of course, would be is that the damages that he says he suffered is something he would need to bring at $100,000 in the magistrate's court. If he's bringing it at VCAT, I wouldn't be worried too much.
Okay, he's also included the real estate agent in it and said that he wants the real estate agent deregistered because he's racist.
Because he's racist. I'm not sure that that's a reason for getting rid of the estate agent, but so I wouldn't I really wouldn't be too worried, Helen.
Helen, an unpleasant situation
It's been
all round.
hanging over my head for about 2 years, and I'm just waiting for the VCAT queue to come through, and it's causing me a brain tumour.
So, Helen, with the estate agent, sit down and do the chronology so you can work out what happened and when. A damages claim won't get up at VCAT, and there would need to be medical evidence linking the two, and from what you've told me, you don't have that.
Helen, best of luck with that. We're going to try and squeeze in at least one more call, also from Torquay. Bev has a question for you. Hi, Bev. What's your question for David?
Okay, David, my son and daughter-in-law, they bought a block in Lower Mount Dunedin, and next to it was farmland. Now, they've built the house. The farmland has been sold to a developer. They want to put up a fence, but the developer said they don't have to pay half the cost of the fence. Is that correct?
You would need to look at your son and daughter-in-law's contract, Bev.
Right.
I act for a couple of developers, and I can say that I normally put a clause in my contracts that says if you buy a block of land from me, you won't ask me to contribute to the cost of a dividing fence. So if there is if it's a different developer who's developing next door, that's not your problem. So yes, you are entitled to follow the process in the Fences Act to force a fencing outcome.
All right, so they should. That's what I thought. Okay, so where do we go to?
You start with a fencing quote, and you serve the fencing quote with a fencing notice on your neighbour. If you don't get the answer that you want there, you go off to the magistrates court. And tell me, how long is the common boundary, Bev?
Well, I know that it's $1,000 they're asking for the developer next door.
Okay, so it's not a particularly long fence.
No, no.
But I would be I'd be having a discussion with the developer, because the developer will want some form of uniformity of fences along that boundary. So see whether you can't do a deal.
Yeah, the developer has come back saying that we can ask the people who eventually buy the block to contribute to the fence.
You can, but once the fence is up, there's no basis for asking for the contribution to a fence, because there isn't a fence needed anymore.
Oh, I've got you. So you have to do it before the fence goes up.
Indeed you do, Bev. Indeed you do.
Bev, you've got some homework to do there.
I think it might be a tad too late. I think the fence went up this week, so it looks like they're going to have to wear the cost of that one, unfortunately.
It sounds like it, Bev. Thank you.
Bev,
thank you.
Thank you for calling in, and thank you to everyone who has called in, and apologies to the calls that we can't get to. Please try again next week on David Whiting's regular segment, of course. And David, thank you so much for travelling here to our pop-up studio in Geelong. Are you going to go and have a nice lunch at one of these beautiful cafes and restaurants?
No, I'm going back, but any opportunity to get out of the office is my philosophy. Thank you, Mary.
Absolutely. Lovely to see you in person. David Whiting there, who has been giving you your free legal advice, and with a little bit of applause from the audience who's been outside that glass panel looking at us here on the waterfront in Geelong.